full vote.
They've had
So I feel like I can't imagine like
okay, guys.
disrupting that again.
Yeah. We're gonna go ahead and get started. So thank you all for being here. Thank you very much. You're clearly the winner of today's training. Sorry about that. So for those of you who don't know me, my name is Donna Mizrahi. I am a litigation associate here at the firm. I spent my NAP year fellowship at Volunteer Lawyers Project handling guardianship and family law. And then when I started at Ropes, I am now the leader of the VLP guardianship group here at the firm. So I'm thrilled to see you all here. I'm hoping you guys are all going to get very involved in some kind of pro bono. Obviously, my choice would be guardianship, but as you wish. But I really do appreciate you guys all coming out. With me today is the esteemed guardianship expert, Veronica Serrato, and she is a staff attorney at Volunteer Lawyers Project and is kind enough to come over here and help me lead this training. She's a great resource. If you have guardianship questions, you should definitely reach out to her. You can reach out to me first, and then if I don't understand how to handle them, I refer you to Veronica. She's really the expert. And then also with us today is Bill Patton, who is a retired partner here at the firm, and who also generously gives of his time to help with the guardianship project. So I'm going to let both of them speak a little bit if they'd like to.
Well, I won't say very much. When you came in the orientation, you had an introduction to Ropes and Grace pro bono work, and the firm has a long tradition of pro bono work. Starting when I started, the case that was often talked about was the defense of Admiral Kimmel after Pearl Harbor. Ropes and Gray was both his Navy and civilian counsel, and we've had a number of death penalty cases in Alabama, and recently, at least since I retired, I was at Ropes and Gray probably almost more than the combined ages of everybody here for 40 years. And after I retired, I started doing work with the Volunteer Lawyers Project, and particularly in the family law area. And the guardianship cases are terrific vehicles for people starting out, because you get to exercise all of the aspects of being a lawyer, including listening to clients, giving advice, setting expectations, and appearing in court. Appearances are brief, but it's a good experience to stand up in front of a judge and represent a real live client. And it's very important work. The people that we represent would be on their own, and you only have to visit the probate court to imagine what a layperson would make of the whole proceeding. It's hard enough when you're trained as we are. So it's a real service, and I think it's also a great experience. So today you have the opportunity to be trained. The training after today's session with Donna and Veronica, you'll know everything you need to know about handling a guardianship case. And I'm going to stop now, but just to say that we have this list of cases that VLP has put out for referral. There are 2 guardianship cases, and they're for beginners. So I hope after today some among you take these cases, because they're very, I can't stress enough how straightforward they are, and you get all the support you need. You can do these also with a partner if you think that's more desirable. We can provide coverage if dates come up and don't work. So with that, if you want to say something.
I want to say a couple things just briefly. One is to really thank you all for being here. Our collaboration with Ropes and Gray has been incredible. Bill and Don are both very humble. So I will tell you that you are in very good hands here. Donna is extremely intelligent and very competent and very organized.
Can you call my mom and tell her?
Yes. And when she's covering the clinic, I really do rest easy. So you really have an expert here in the office, which is tremendous. And Bill won't tell you that he won 2 awards last year, at least 2. One from Lawyers Weekly, and a second was the Gideon's Trumpet Award from Volunteer Lawyers Project for all of his work with VLP, and he's now an Access to Justice Fellow. So to have any opportunity to sit down and talk to Bill for any amount of time would be a gift. And the last thing I want to say is that you really could go to the guardianship clinics right now and pick up a case and help someone, and they would be better off for your help. These forms and papers were all designed to be used by pro se litigants. They're just not well written, which is why it doesn't work for pro se litigants. But I'm confident you could all help out right now. So don't let what we talk about and the nuance and the details deter you from just jumping in. Law school, for some reason, has a way of scaring us, right? We're willing to do things before we go to law school. We get 3 years of education, and all of a sudden we're timid. So I hope to see you all in court or on a case.
And while I'm thinking about it, I will be running the VLP court clinic next Tuesday. If anyone is interested in going when there's another ropes person there, I will be there. I would be happy to give you a tour and show you around and make sure that you're comfortable. The clinic is from 9 a.m. to 1 p.m. at the Suffolk Probate and Family Court on New Chardon Street. So if any of you are interested, feel free to reach out to me after the training and I can set you up with that process. And the clinic happens every week, twice a week. It just so happens that I'm there next week. It's not always the case. So with that being said, I think we're just going to go ahead and get started. There is an attendance list going around, so if you could please make sure that you sign that before you leave today. So all of you have the PowerPoint in front of you. Like that. And so if you want to follow along as we go, then that would be great. Please feel free to interrupt with questions along the way. So this is certainly intended for your purposes. If there's anything you don't understand, please let us know. Okay, so at the outset, there are 2 types of guardianship. There's guardianship of a minor and guardianship of an adult. And so the basic difference there is that a guardianship of a minor is for children who are under the age of 18. And what's going to happen there is that the guardian is basically acting like a parent. And then a guardianship of an adult is for incapacitated or intellectually disabled people. So these are adults who are unable to make their own decisions and need someone appointed to make decisions on their behalf. There's also 2 different durations for guardianship. They can either be a temporary guardianship or a permanent guardianship, and the difference there is that a temporary guardianship is only filed when there's an emergency. Now, for guardianships of minors, the court considers any case where a minor does not have a legal guardian and a parent, a caretaker, someone taking care of them, to be an emergency. So for guardianships of minors, we routinely file temporary guardianship paperwork. For guardianships of adult, we usually just file the temporary paperwork if there truly is some type of emergency. And then the temporary guardianship is going to only be valid for 90 days. And after that point, you then have to go back to court for another hearing and seek, well, I guess I should say the hearing is for permanent guardianship. The name permanent guardianship is a bit misleading, and it often confuses our clients, especially when they're coming to court seeking a guardianship just, quote unquote, on a temporary basis until the parents get back on their feet. Permanent guardianship really means until further order of the court. It does not mean permanent. It means until someone comes back to court and requests that the guardianship end or that the guardian comes to court and asks to resign. It can last for a long time, but it does not necessarily have to. And that can provide a lot of comfort for guardians as well as for parents who are going through this process, who are concerned that they are, in effect, giving up their children. That's not at all what's happening. So it's important to understand that distinction. Just the point of procedure. There is no such thing as a petition for temporary guardianship. It's a petition for guardianship is the permanent guardianship paperwork. And there's also not a motion for permanent guardianship. So to get a temporary guardianship, you have to file a motion. To get permanent guardianship, you have to file a petition. Our clients and people who are looking for our help certainly do not understand that distinction.
You have to file a motion for temporary under a petition for guardianship. So everyone has to file the petition for guardianship. The motion is extra.
We get clients who come to court all the time asking, I need to file for temporary guardianship. And there's no way to just file for temporary guardianship. You have to file a petition, meaning you have to be seeking permanent guardianship, and they do not understand that, which is why it's important to understand, as we were just talking about, that the permanent guardianship is not, in fact, permanent. It's permanent until further order of the court. And just to take a step back and kind of have a sense of what is a guardianship, you're basically asking that someone be appointed to be able to care for a minor or for an incapacitated adult. That's what a guardianship is. And the respondent is the subject of the guardianship. So throughout this training, I'm going to refer to the respondent, and what I mean by that is either the minor child or the incapacitated adult. I'm trying to do a training on both minors and adults at the same time, and so it can get a bit confusing. So a guardian does have some financial powers, but they are very limited. A guardian can become the representative payee, meaning that if a respondent receives Social Security benefits, the guardian can be appointed as the person designated to receive those benefits, and the guardian can find out how much money a respondent has in the bank. But that's basically all the guardian can do. Beyond that, the guardian is going to need to apply for conservatorship, and that's, for example, if a respondent has a home that needs to be sold, which is common in guardianships of adults, the guardian is going to need to seek a conservatorship. It's separate from guardianship, and that's something that changed when the law changed in 2009. It used to all be jumbled up together, and then they separated it out. So the guardian is going to have limited financial powers as guardian and may need to seek additional powers as conservator. Maybe. Depends on the case.
So isn't it, though, that almost every client that we see through the Volunteer Lawyers Project doesn't have any assets?
Right, and that's an excellent point. So for the majority of our clients, a conservatorship is really not going to be appropriate. There's not an estate to talk about. There's not really any money that's there, and it's not going to be necessary. It's just that you need to be aware that if a guardian is trying to do anything financial, they're probably not going to be able to do that. So a guardian has certain duties, and it's what you would think that it would be. It's that they need to take care of the respondent. They need to act in the respondent's best interest. It's not anything out there. It's just a matter of making sure that the respondent is cared for. And for guardians of adults, there are additional duties, mainly respecting the respondent's individuality and encouraging the respondent to participate in decision-making as much as possible. The court really wants, there's a preference for limited guardianships for adults. They really want adults to be able to do as much as they can do and only have the guardian take over where the respondent, the incapacitated person, is not capable of doing what needs to be done. The guardian also has certain rights. For one thing, guardians will not be liable to third persons for the respondent's actions. So they can rest easy to some extent, but there will be consequences for the respondent's actions depending on the situation. So for example, if a minor is selling drugs in the guardian's public housing apartment, that will still be a problem, and the guardian could still be evicted for that. So technically, the guardian might not be responsible for the actions of the respondent, but there will still be consequences. They are taking care of the person. So.
Okay. Yes. So there's a lot of training materials in front of you. Don't be intimidated by them. They're really more of a resource for you to consult them later. Do ask questions as we go along. So I want to sort of make more sense to you if it's not. The people that we're seeing, or the people looking for guardianship, are folks who have small children with them where the mom is dead, dad is parts unknown, mom just went to jail, mom's in drug rehab. Those are the real cases that we see. Sometimes we see a mom who's dying of cancer and the family sort of mobilizing around her. Does that all make sense to you, right? You're all children. Some of you maybe have children. When a child needs another guardian, it's because both parents are unavailable. Pretty straightforward. That's pretty easy to establish once they're not around. Don already touched on permanent doesn't mean irrevocable. So guardianship is very much not adoption. Once you are adopted, you get a new birth certificate with the new names, the parents' new names on the birth certificate, and the parents, the biological parents' rights are completely severed. They have no rights or obligation. Guardianship's totally different. In guardianship, they can file a motion or a petition to end the guardianship at any time, a petition to remove the guardian. So there's ongoing parental rights and obligations. For adults, it's very different, right? What prevents someone from going to court right now and getting a guardianship of any of you? Well, the answer is they have to have some medical evidence. There has to be some medical evidence that there's a need for guardianship. So the grounds for adults are very different. For an incapacitated adult, they're going to be the court's going to be looking for you to show some clinical diagnosis that has an impact on activities of daily living. Does that mean anything to anybody? So what can the person not do? Why does the person need a guardian? So I'm nearsighted and I have a bad memory. That doesn't mean I need a guardian. Not yet. You've got to show more. So the kinds of people we're looking at are stroke victims, Alzheimer's, early Alzheimer's, dementia in whatever other form, elderly people who are not doing well. The other category of people we're helping and seeing are the intellectually disabled. This used to be called mental retardation, and then Massachusetts changed the statute, so we don't say mentally retarded anymore. And again, it's a functional analysis. What can the person do and not do? Intellectual disability is usually an IQ of 70 or less, which, if you can imagine that for a minute, is pretty low. It's pretty low functioning. So when you see our blurbs of the cases and you read the memos, it'll say the person can or cannot feed himself, the person can shower, the person can or cannot speak. I mean, we've got a lot of nonverbal respondents, feeding tubes, really the severe end of the disabled population. These are not close calls. When you need a guardianship for an incapacitated adult when there's no one to make a decision. So that happens when either an otherwise or a previously competent adult falls ill, and there's no one to make a decision. Massachusetts does not have a kinship statute so all the stuff you see on TV that the wife gets to make the decisions in the emergency room, it's fiction. There's no statute in Massachusetts, so people have to fight about it. And that's when you would go to guardianship. If you have a healthcare proxy, you're not going to need a guardianship probably. You should all have healthcare proxies. Don't get me started on this. You should all have healthcare proxies, and you can ask Don about it later. So the times that people go to court for adults is when they're getting pushback from either an agency like Mass Health or the Boston Public Schools, and they're saying no one has authority to sign off for this person, this adult. This is an 18-year-old. And so the parents or family members have to go to court to get that authority to sign off. Common examples are removal of wisdom teeth, any anesthesia. You can imagine a doctor is not going to want to put someone under anesthesia unless there's a legal guardian to sign off. So those are the sorts of cases that we're seeing. The other, go ahead.
No, go ahead.
The other is when a child was always impaired, always cognitively impaired since birth or early on, and they reach age 18. So parents who previously were able to make decisions, all decisions for this child, are now out of the picture because the child has turned 18, and that legal action, that legal happening has tremendous consequences everywhere, and then the parents have to go to court to have any authority to continue making decisions for this child. Go ahead.
So just to clarify, for the adult population, we see two different groups for the most part. We see elderly parents where a child or a loved one is coming to court seeking to become the guardian of the elderly person because they have Alzheimer's, dementia, what have you. And we see parents coming to court seeking to become the guardian of their 18 or 21-year-old child who has Down syndrome or something like that and is unable to make their own decisions.
Okay, so as I said, you can't get a guardianship just because you're making poor decisions. So sometimes we'll see, not often, but we'll see an adult child come and say, my mother or my father has a new boyfriend, a new girlfriend, they're spending all their money, I don't like the new boyfriend, I want a guardianship. That's not a guardianship. That does not arise. It's not about poor judgment. We all have the right to refuse medical treatment. We all have the right to refuse life-saving medical treatment. I can refuse chemo. I can refuse any intervention. That's within my right. So it's got to be more than bad judgment. It's got to be a sort of a danger situation. Yes?
So it always has to be sort of rooted in the medical, because, for example,
Yes.
bad decision is one thing, but you might say there's clear evidence of fraud or real kind of manipulation that even might go a little bit beyond bad judgment, and it's just like they're being taken advantage of, but I imagine that there would still be rooted in
Medical diagnosis.
Okay.
You got to start with the medical diagnosis and then show the rest. And if the person holds the healthcare proxy and is the power of attorney and is taking advantage of that person, that a guardianship's not going to fix that necessarily. There's going to be other problems. Okay. The court has a preference for limited guardianship. This is under the statute that Donna referenced that passed in 2009. So the court really tries to only grant as much authority as is necessary. And the guardian, as Donna said, has an obligation to actually notify the court if the guardianship is no longer necessary. Now, again, as I said, in our cases with these incapacitated adults, they're extreme. I don't see people regaining capacity. Sometimes they wake up from a coma. That's good news. But by and large, these are for life. So you should know all this by way of background so you understand the law and you can apply it in cases that are on the line, or so that you have a better understanding. But it's not going to be an issue.
So now we're going to talk about the nuts and bolts of how to get the guardianship. So this is the civil procedure portion of the programming for those of you who like Civ Pro in law school. So who can file the petition? Basically anyone. Anyone interested in the respondent's welfare can file the petition. The minor and the incapacitated person can also file the petition. For the incapacitated person, I don't think that would ever happen because, as we've discussed, they don't have capacity to be doing things like that. And it's very rare that the minor is the one who comes to court. Usually it's the person who is seeking to be appointed guardian who files the petition. But really anyone who's interested in the child's welfare can do that. So just a note about jurisdiction. For minors, there's a requirement that the child be living in Massachusetts for 6 months in order for a Massachusetts court to have jurisdiction. And what happens, this actually happens more often than you would think. For example, we have a client coming to court looking for guardianship of children who just came off the plane from the Dominican Republic last week, and the potential guardian is now coming to court to make things formal, and the problem is the kids haven't been living in Massachusetts for 6 months. It's not an issue. Courts routinely allow these petitions to go forward. They're called permission to file cases, and basically there's just an extra procedural hurdle where the guardian is going to have to go before a judge and literally get permission to file the petition, but it's routinely granted.
We saw a lot of kids after the earthquake in Haiti coming, and I have never seen permission to file denied, but it's just, as Donna said, an extra step, more waiting.
So the proper venue for a petition to be filed in is based on where the respondent lives. It's not based on where the petitioner lives. It's based on where the child or the incapacitated person lives. And this can sometimes get a bit tricky when the child is in flux, for example, going between mom and grandma, not quite clear where she's living, and it can sometimes be a little bit more complicated than you might think. So it is something to be aware of, but the general rule is that venue is where the child lives. Facts sometimes complicate that. So we've talked about how you can apply for guardianship, and I just want to touch on who is going to be appointed guardian once you do that application. So generally speaking, there is no difference or priority given between people who are related to the respondent and people who are unrelated. We have a lot of people who approach the clinic table at court and tell us that they are, like a step-parent or something like that, and then when you probe a little bit more deeply, it's like, oh, you weren't married, you're really just, the father's girlfriend or a family friend, and sometimes people will create a family bond because they're worried that matters, and it really doesn't. There's also no priority among family members, so a grandparent has just as much weight to become a guardian as an uncle. It does not matter. And there's no priority between maternal and paternal relatives. Sometimes we have dueling grandmas, and the maternal grandma will sometimes say, but I'm the maternal grandmother. It doesn't matter. Court does not care.
There is one familial priority, and I'm not sure where it went in the slides, because we have reworked these slides many times to make it better. The spouse is the first priority for an incapacitated adult, and then the parent of the incapacitated adult is second priority, and then the rest of the world. So everything Donna said is true, except for that. So if my husband and mother show up at court and are both filing for guardianship, my husband takes priority.
And I think I was also referencing minors more specifically.
Right. And that's why this is a little confusing, because we're trying to do both at one time, but we think you're all of above average intelligence and you can handle that, and that's why we've decided to do it.
And also specifically for minors, if they are 14 years or older, they have a lot of power in this process, as you will learn today. And a minor's desire as to who he or she wants to be his or her guardian will trump all, even if there is a will that says someone else should be appointed, and even if the parents say that someone else should be appointed. So it's a little bit frightening to some extent. But the only exception there is that if the minor is seeking to have someone appointed who's not in their best interest, the court's not going to let that happen. So if the minor comes to court and says, I love my 19-year-old boyfriend, I really want him to be my guardian, not going to happen. Sorry. There are also limitations on who the court will appoint as guardian. Not everyone can become the guardian, but there are not stringent limitations, as you will see. So if you actually read the text of this slide, you will see that someone who's currently investigated or has charges pending for committing an assault and battery that resulted in serious bodily injury to the respondent or neglect of the respondent is not going to be appointed guardian. The courts have interpreted the respondent to refer to this respondent. So that means that if a guardian has abused or neglected other respondents, that will not preclude them from becoming guardian of this respondent. I know that's disturbing. That's the way it is. The reality, though, is that the court is going to run a criminal background check every time that the potential guardian goes to court for a hearing. And if someone has a very long record, they're not going to be appointed guardian. But drug convictions and OUIs are not going to prevent someone from becoming a guardian, especially if we know about it ahead of time. There is a place on the petition where you need to inquire if someone has been investigated or is charged with anything right now. So just something to be aware. So counsel is available in most cases, in the sense that any time someone requests counsel for a respondent, it is a mandatory appointment, which I find a lot of solace in, and anyone can file that request. But the reality is that counsel is, I would say, not often requested, and usually appointed, I would say most often in contested cases where not everyone agrees who should become the guardian.
I brought a request for counsel form, a little bit of show and tell, just to pass around so you could just sort of see it, so that this makes a little bit of sense to give some body to what we're talking about.
It's also possible that the court will appoint a guardian ad litem or order a family service officer, a probation officer, to investigate the respondent's condition. There is a difference among attorneys, GALs, and an FSO investigation. So just very briefly, the attorney is going to represent what the respondent wants and not necessarily what's in the respondent's best interest. And because it is an attorney-client relationship, there will be attorney-client privilege. A GAL, on the other hand, is not going to have that privilege attached and is only going to be reporting on the respondent's best interest, not what the respondent wants. And FSO, again, there's not going to be privilege. They're not going to do a best interest analysis. They're just going to report to the judge as to what they observe. The reality is that your best bet, if you would like an attorney, a GAL, or an FSO officer appointed, is to request the attorney because it's paid for by the state. The GAL and the FSO officer are paid for by the court. And in case you have missed it, the court has very limited funding available. It's very strapped for funds at the moment. So the respondent does have a right to attend the guardianship hearing. For guardianships of adult, it's not always a good idea in the sense that it may actually upset them, depending on their medical diagnosis, to be in a crowded place with a lot of people. It may be very hard for them to get there. So it's certainly not a requirement, but if they would like to attend, they have that right.
And we tell all our clients that the child should never come. The child should always be in school and not to bring the incapacitated adult ever. The worst that would happen is the judge might say, well, I really want to lay eyes upon this person. There'd be a subsequent hearing. But for most of our cases, worrying about things like where to change an adult's diaper, hydration, need a nap, wheelchairs, just the logistics make it very difficult to bring someone to court. Sometimes they vocalize, they just start grunting or shouting, and it's very disruptive to the court, and they end up waiting in the hallway with this person, which sort of defeats the whole point of being there.
Do you routinely file a motion for permission or asking that the respondent be excused?
You don't even have to file a motion. You just don't bring them, and then if it comes up, you would only have to do a motion to waive the person's appearance if they're represented by counsel, and then the attorney could. But so it's not an issue.
So anyone, okay, so in terms of objections, if a party does not agree with what is happening, with the fact that the guardian is seeking to become the guardian, that interested person can file what's called an appearance and objection.
I don't.
Oh,
I'm sorry.
That's okay.
Our computer crashed at noon today. It was not pretty.
Oh, that's helpful.
Yeah.
So this form has to be filed by an interested person, which is in contrast to the application for permission to provide information, which anyone can file if they feel like this guardianship is not a good idea.
Which I do have.
Show and tell.
I'll pass it around.
So the worst case scenario is that this form would be used by a busybody neighbor. I don't think busybody neighbors are going to that effort to make this happen, but an example of how it can be used effectively and how it has been used effectively in the past is there was a case where a woman had sole custody, she passed away, and then her husband had abused the kids in the past and went to court looking to get custody of the children. And the wife's lawyer filed this form to let a judge know in a different county that the abuse had occurred so that the father did not end up getting custody. So it's good to know that it's out there. So just to give you an overall sense of what the steps are, the way that this process works is that a client is going to most likely come to the clinic that we talked about earlier today at one of the courts and file petition paperwork. They may do it on their own because we're not in court every day, or they may wait until we are there and come to the clinic. And then after the paperwork is filed, there is a temporary hearing. After that temporary hearing, an attorney is supposed to provide post-appointment notice that the guardian has been appointed as guardian. And the attorney then needs to take care of service before the permanent hearing. And then the attorney goes to the permanent hearing with the client and should leave there with guardianship. So it is fairly straightforward, as Bill was talking about before. It's usually a very short process. These cases typically last, I would say, 3 to 5 months at most. depending on how quickly the court is moving. So they are very, it's a short-term commitment in that sense. It's a great thing to do right when you get to ropes and gray before you build up your caseload.
There's also long delays in which you will do nothing. Right?
That's also a good point.
I mean, you file the petition and then you wait.
Right. You're not going to be working on this case actively every day, by no means.
So I'm going to talk about service of process, I promise, but it's more civil procedure. But I want to ask David, who I know was in court this past Tuesday, to talk about your impressions. Was it your first time in a court?
In that kind of court.
Okay, what did you see? How did it feel?
I was really disorganized. The clerk gave us inaccurate. There was a lot of going upstairs and downstairs between the probation office and then the courtroom. And the clerk at the court who we were filing the documents with was misinformed about the law, and so she was going to reject the whole petition and make us reschedule for a hearing in January. And then we went down to the clinic table and had a conversation and realized the clerk was wrong. And we went back up and told her what the law was and why she was wrong. And then there was a background check involved, and the background check office didn't want to see anybody before a certain time of the day. So anyways, it was kind of a disorganized
chaos.
It sounds like a typical day at Suffolk Court.
It's a typical day. That's the context in which you sort of need to understand service of process and how you can help litigants, because they really don't get it. This happened before. Okay. Service of process makes sense to all of you, right? There's a petition or a complaint, and you've got to notify the other side so they have an opportunity to respond. Pretty basic. Our litigants don't get it, and they don't get it for a lot of reasons. So I want to make just a few basic points about service of process, and when you have a case and you're trying to do service, you'll come back to the materials and figure out how to do it correctly, because you really need to look at these rules over and over again before you memorize them. You have to give notice before a hearing on a motion for temporary guardianship. That makes sense to all of you. It doesn't make sense to our clients. You also have to give notice of the petition for permanent guardianship if you're seeking permanent guardianship, right? You can't just show up to court and not tell anyone and expect to leave with temporary guardianship. That's what our clients do day in and day out. So for temporary guardianship, you have to give notice 7 days and prior, and for permanent guardianship, it's 14 days. 7, 14. Simple. You with me so far? On the temporary guardianship, you always have to give in-hand service to the incapacitated person. Always. It doesn't matter that they're in a coma. It doesn't matter that they can't read or write. It doesn't matter that they're blind. It doesn't matter that they don't speak or read or English. It just doesn't matter. So every week, if you come to the clinic, someone starts with the but, and it's really hard to listen. And then you say, this is what you need to do. But it's like, this is what you need to do. For everybody else, there's another group of in-hand. For adults, everybody else is served by mail. Just regular first-class mail. Unless you're pro se, then you're supposed to provide proof of mailing. So the post office charges you $1 for each piece of mail to show proof of mailing. Lawyers don't have to do that. So just by you being willing to do service of process for them, you get to sign, you get regular mail, and you don't have to show any proof of mailing. So you've already saved them the line at the post office, which is tremendous right now. Adults, the parents of kids also have to be served in hand. So the respondent always and the parents of the kids in hand. In hand. It doesn't matter. Remember service of process, it has to cross the plane, touch the person, fall to the ground, doesn't have to be open. That's fine. That's all it takes. And then there's this middle step, which no one does, which you're supposed to give notice if you get temporary guardianship that you got temporary guardianship, so that the other side has the opportunity to come in and file a motion to vacate and have a hearing de novo. For this notice, if the person is parts unknown, you're not going to be able to do mail in advance, right? The court understands that. For permanent guardianship, if the person is parts unknown, you're going to have to do service by publication. This is a true legal fiction that our clients just can't comprehend. Publishing, for example, in the Bay State Banner when no one's going to see it, much less this unknown father, is just that. It's a legal fiction. So if the birth certificate for a young child is blank, or they just don't know who the father is for whatever reason, rape, domestic violence, one-night stand, you're going to have to do a motion for service by publication. If there is a dad, and it's almost always the dad, if there is a dad but he's just not been involved in the child's life, that doesn't matter. If there's a dad and they know the dad's name, that person has to be served in hand. If these parts unknown, you can do service by publication. Okay? There's a fee waiver, which we'll cover later, so that the court will cover the cost of doing this, so the litigants don't have to pay for this out of pocket. It's about $100, $150 to put a little classified ad. Yes?
What's the threshold in terms of knowing where that other person lives? I'm sure there's like, oh, I think he lives in Medford. But
Oh, we get a lot of that.
So I'm just curious, like, is
You have to be able to serve them in hand. If you don't have enough to serve them in hand by constable or disinterested person, you're going to need to do service by publication.
Okay.
So
Medford's
Medford's not going to cover.
Not enough.
Yeah. Okay.
Sometimes they'll say, I don't know the address, but if I drove by there, I could get the address. Like, do that. Right? That's a good idea.
Service in hand is much easier than service by publication, so if you can avoid it, it's definitely a good idea.
It's also more honest. Right. You don't want to go to you don't want the judge to say, well, where do you last know? I've seen one judge in particular say to a ropes attorney, did you go through the person's cell phone and look for the address of the dad after the mom died? Did you go through the person's belongings to look for an address? So you want to do, not your level of due diligence, not what Donna does for a case here, but asking some questions. We also have access to the Lexis Search Clear, and we can look for them, and we would do that for you before you took the case, just to see if we can find the person. If they have a really common name, like Jose Gonzalez, it's going to be hard to find them. But if they have a little bit more unusual, or we have a date of birth or part of a Social Security number, we can usually find them. You had a question? 2 questions.
Who does the service? Like, what if this person is concerned about violence or something like that when they're serving?
In hand, you mean?
Yeah, for the
a constable
in-hand
or
service.
any disinterested person, anyone over 18. It shouldn't be any of you, if that's what you're asking.
And where does the person find this, like the constable?
Well, you as lawyer would go to the sheriff's office for that county where the person lives or works, where he's going to be served or she's going to be served. We've been having some trouble with the usual constables not accepting fee waivers, so we're better off with the sheriff's office. And it's pretty simple for all of you. You put certain things in an envelope and you get certain things back. But for a pro se litigant, there's too many moving parts. It's procedurally too complicated. But they're in the business of serving people.
When you said violence, did you mean that you were worried that upon serving the papers, there would be domestic violence between the couple?
Or some.
Okay.
Between the server and the servee.
Yeah, I imagined that, like, let's say someone is seeking guardianship over a minor child, and there are parents involved. Like, perhaps the guardian might be worried about the parents reacting negatively.
So there's also an option to have, if there is that fear, an actual fear of violence, there is a way that when you file the initial paperwork, you can ask the court that your address be impounded, that the guardian's address be impounded, so that hopefully would not then be the case, would not happen.
Yeah, and I don't think it's something you should be concerned about. I've been practicing since you guys were born, and have worked for the district attorney's office, have worked for a battered women's shelter, and we've done like lots of safety planning and lots of different things, and I've never had anything bad happen with some normal amount of planning and questioning, and you're not going to send grandma to serve dad.
Yeah.
Not a good idea.
Okay.
But if you just sort of do some normal amount of thinking about things, you can plan.
We used to use AAA.
They're not taking the fee waivers anymore. Yeah.
Yeah, that's a problem.
Because the Commonwealth wasn't paying them quickly enough. They got sick of waiting. Someone had a question over here.
I just wanted to make sure you don't need to publish for temporary guardianship before you obtain that.
Right. So the publication is only if someone's part's unknown, and if you have that, you're going to come back to this slide to see, well, what do I get back from the newspaper? And it just tells you right here, you're going to go to court with the return of service form, you're going to fill it out, and you're going to give the court the uncut tear sheet from the newspaper along with the certified mail that got returned to you as undeliverable if you had a good enough address to send it out. Okay?
And just to add a note, I think one of the hardest things for our clients to understand is service by publication. Mm-hmm. Because it's quite often the case that they don't know who dad is, one night stand, what have you. And so they're like, what do you mean I have to serve dad? I don't know who he is. And you have to explain to them, I understand you don't know who he is. It's a legal fiction. Bear with me. This is what the court requires. And I think, when they try and do it on their own, they look at it, they laugh. They're like, okay, I don't have to do this. And then their case cannot go forward. So that's something that we as attorneys can really help them with. To speak briefly about the limitations on guardianship. So a guardian is going to need special court authority to do a lot of things beyond the normal caring for the respondent. So, for example, to commit I'm just going to skip that one for a moment. To commit a respondent to a psychiatric facility, the guardian is going to need to go to court and get special authority for that. To treat the respondent with antipsychotic medication, that's also going to need special court authority. And the antipsychotic drug cases are known as Rogers cases, based on this case. And in that situation, the court is going to apply substituted judgment, which basically means that the court considers, would the respondent consent to the treatment if the respondent were not in fact incapacitated. That is the advanced guardianship situation. We are not starting you out on Rogers cases. There are a couple more procedural steps that are involved there. So it's just to make you aware that it's a situation that exists, but you are not at all supposed to be able to handle those yet. Not yet, of course. And then we already touched on the fact that a healthcare proxy is going to trump a guardianship. So if there's a healthcare proxy in place, you may not need the guardianship after all. Let me just go back for 1 second. Veronica's going to touch on admission to nursing facilities.
So the statute says that no guardian can put anyone in a nursing home without court authority, and that's still the case, but there's a little bit of a wrinkle. In August of 2012, the court issued a new press release and a form, which I'll pass around, and Donna can send you by email if she thinks it's worth your time. But basically, what happened was that the hospitals were all up in arms that they were having to go to court to get a guardianship before they could put anyone in a nursing home over and over again. That's a lot of work. That's a lot of lawyers. So the new process says, and there's so many parts that you'll see why it doesn't work for us. If a licensed healthcare provider thinks it's needed, and there's no objection from the incapacitated person or any interested party, anyone in the case, and a written notice of intent to put the person in a nursing home is served upon the respondent and the nursing home, and the respondent is represented by counsel who does not object, you can do it by paper, not have to go to court. That doesn't happen it's just too many pieces.
There's not going to be a lawyer.
There's not going to be a lawyer on the other side, so it doesn't work. So we're still having to get nursing home authority at court.
It was nice of them to try.
And for some cases it will help, but not for most.
Okay, so going back to where I was before. So after a guardian is appointed, there are reporting requirements. So the court is going to require for guardianships of minors that a guardian file an annual report, and for guardianships of adults, 60 days. After being appointed guardian, the guardian has to file a report, and then again annually. VLP is really good about helping with these annual reports, and as we'll talk about later, you guys are not expected to stay in the case for that long and be obligated every year to handle these reports. It's just that you need to know that they exist so that you can properly advise your client. Don't forget, now that you're guardian, you've got to comply with these reporting requirements.
And it's 60 days after permanent and annually after on the anniversary of the permanent.
So we've gone to all this work, we've gotten the guardianship in place, and now we want to terminate the guardianship. So how does that happen? So it can happen automatically, when a child turns 18 or gets married, if it happens to be before the age of 18, that will terminate the guardianship. If either the child, the incapacitated adult, or the guardian passes away, that will also terminate the guardianship. I actually just had someone at Ropes and Gray who called me and said, the respondent incapacitated person died. My client, the guardian, wants to know what he has to do. And I said, well, nothing. The guardianship is now over. It just automatically ends. There's also a way, if someone wants to terminate the guardianship before its natural ending, to go to court and seek as guardian to be removed or to resign. So the court is going to have to approve that. It's not automatic, but generally speaking, the court will honor the wishes so long as there's someone who can take care of the guardian, take care of the respondent. And as we also mentioned, if the incapacitated person becomes capacitated again, the guardianship will terminate. So these are just the forms. I'm skipping that one.
Yeah. Okay. So Donna gave me these really boring slides, finding the forms on the law, and I want you to just sort of look at them. The great thing is that everything is online. For those of you who have an iPhone, you understand there's an app for everything. So this, I want to just show you. I'm going to need help.
Is there an app for the forms?
So these are all the forms on the probate court website.
I only have 2 pens.
Well, there you go. Those are all the forms.
Memorize them.
It's tremendous. I'm going to pass this around just so you can see it. I have this page obviously bookmarked on my computer, and I have downloaded all the forms that I tend to use often because I don't want to wait the 3 minutes it takes to download each form. But the good news is that you really can find a form for everything. The courts sometimes don't know about the forms. So if you know there's a form and you go to court and they're saying, nope, there's no form for that, go on your phone and say, here it is, can you print it out? And they will do it. But they need encouragement sometimes.
The clerk's office.
The clerk's office. There's the statutes online. You can find it in a number of places without using Westlaw or Lexis, which is why this is such a great area of law. Everything is on your desktop. The second site is the official one of Mass General Laws. I don't know if any of you have ever had to look at it yet. Yes? Okay, some of you are nodding. And the first one is unofficial, but it has some comments from an attorney, Mark Leahy, which are helpful to read the footnotes if you practice in this area. There are some standing orders you should be familiar with if you do this. There's some rules and guidelines that you can look at. There's uniform practices also available. And there will be case law eventually. There isn't any yet under this new Uniform Probate Code that Massachusetts created and adopted. But having said that, and this is going to sound funny, but you really don't need to know the law to do guardianship. This is really a good primer. It gives you lots of basic sites, and this is what you need. It's great if you want to go back and read it and get into the nuts and bolts. But our litigants come and go and get permanent guardianship without ever going online and without ever looking at the law. So don't be intimidated. It's more as a resource for you, because I have had very good experience with Ropes and Gray attorneys who want to understand not just what I'm saying, but why, and they want to go back to the source of law. So there it is.
So specifically about guardianship of minors, not talking about the adults for the moment, we're putting that aside. So as we mentioned earlier, a minor who's 14 years and older has a lot of authority during this process. And one of the things that the minor is allowed to do, and not only allowed, but has to do, is to consent and nominate his guardian as his guardian. So the minor's going to have to agree to the person being appointed on his behalf. This next slide is my favorite. It tells you everything that you have to file. It's very helpful. When you go to court, the clerk's office will hand you a packet full of forms. This is what the packet is. They put it all together for you.
You have a sample.
Yes. So, and if you actually want to go ahead and find your sample, it's the Petition for Appointment of Guardian of Minor. That's the sample we're looking at. And it's already been filled in to kind of give you a sense of what it should look like. So, just briefly, I just want to kind of go through the petition and just hit the highlights very briefly. So for one thing, you're going to need one of these whole packets per child. So when a grandma comes to court and she's got 3 of her grandchildren and they all need guardianship, that's 3 of these, which is why we really can use help at the court, because this, as you can imagine, can take a bit of time to go through and write in all the information.
We would give as many lawyers as there are kids, so you each get a kid. Otherwise, you have to do a lot of, it just gets very complicated.
Yeah. And the petition basically just includes the biographical information about the petitioner, about the minor's parents. You're basically explaining to the court, where are the parents and why can't they be serving as the parents right now? What's going on? And it's, they have on the second page the check boxes for you to fill in as to what's going on in terms of, have the parents died? Have their rights been terminated? Are they unavailable? If so, describe. So it's just letting the court know what the situation is. This petition is what is asking the court for permanent guardianship. That's the actual paperwork for that. A co-guardian is an optional, I don't want to say requirement. It's an option. It's not a requirement. So there is space on the petition, at least, for a co-guardian's information. The rest of the paperwork is not really great for having a co-guardian. It doesn't mean you can't do it. It just means that it'll get a little messy. You just got to draw it in and write it where there's room. But a co-guardian is not at all required. It's sometimes a good idea where grandparents come to court looking to become the guardians of minors, and the grandparents themselves are both a bit old and don't want to take on the responsibility alone in case something should happen to one of them. They want to go ahead and have that backup in place. So it's a good idea in some cases. Usually people come to court already knowing that they want to be co-guardians. It's not usually something, you can suggest it, but usually people are like, I want to do it with so-and-so.
Can I say a couple things?
Please.
It's also a settlement option if there becomes a dispute between a bio parent and a grandparent, to sort of settle it, to say, well, what if we did this co-guardianship? The other is that if we're approached by 2 people who want co-guardianship, we accept them as clients who don't have a conflict of interest, right? Because they're together wanting the same thing. If, however, I'm approached or called by one person and they're exploring and they're saying, well, I want co-guardianship with my boyfriend or with my husband, then I will explain that with a co-guardianship, they're going to need to agree on everything, and if there's a dispute, they have to go to court. And you'd be surprised how many times once I explain that, the person says, okay, I'll do it alone. So I had a client who wanted co-guardianship with her fiance of her disabled child, not this person's disabled child. And I said, the guardianship will survive any divorce. Do you understand that? You want to make sure that you don't have to go back to court twice. And yeah, I'm a lawyer. I'm a pessimist. And she said, then I'll just do guardianship by myself. I was like, okay, when's the wedding?
Veronica's a marriage counselor.
Well, I do a lot of divorce too, so I wanna be careful.
Okay, so moving on. If you look at page 9 in your packets, that is the affidavit disclosing care or custody. And so this form is basically just letting the court know, it's section 7 and 8 in particular, if this child has previously been involved in a custody case of any kind, so divorce, child support, adoption, anything like that where the child has been implicated in a court proceeding, the court wants to know about it. The court wants to know who are the parties involved, and those parties have to receive notice that this guardianship is taking place. So that's basically why that's in there. Page 5 is the consent of the parents. So we talked about earlier how the parents have to be served during this process. If the parents agree to this guardianship, which is often the case, the majority of the cases that VLP refers are those that are uncontested, where the parents do not object to this guardianship going forward, and in many cases even consent to it, this is the form that the parents have to sign in front of a notary, basically saying, yes, I agree to this guardianship, I understand it's permanent guardianship, and I'm okay with this. So quite often at the court clinic, we will have grandparents or aunts, uncles, what have you, come to the table with mom or with dad, who's there to sign the consent that day. It's very common for that to happen. Yes?
Do we have access to notary of the public's?
We do. I'm a notary.
Oh, good.
Yes. But so at the court clinic, most people on VLP staff are a notary. And so usually there's at least one notary in court, if not several. And here at the firm, there's a way to look on the InfoNet to find a notary if you ever need one, or you can just come find me. But there's a way, like by floor, you can see who's on your floor as a notary. Okay. So we talked on page 7, we mentioned before how the ward has to consent and nominate as to who should be his guardian. This is the form that has to be used for that. This also has to be signed in front of a notary. We have had some issues in the past with minors who don't have government-issued IDs. In order to get anything notarized, if you're not aware, you have to have a government-issued ID. So that can sometimes present a problem because, quite often the court will say, well, go get an ID. Well, you need a legal guardian in order to get an ID. So you can see it's kind of a catch-22. VLP has drafted a sample motion to waive this notarization requirement.
I think you drafted it.
VLP has drafted. I don't think I did.
Well, we use it. It's on the card.
In any event, there is a sample motion available if it comes up. It's had some success. Some judges are willing to accept it. Others say, go get an ID. So it kind of depends what the situation is, but there is an option out there, usually. So page 13 is the military affidavit. This form is unique to Suffolk. Its purpose is that if a parent or anyone involved, an interested party in the case, is serving currently in the military, then that person would be appointed an attorney while they are overseas, and their interest would be represented in their absence. I think in all the cases that I've done, I've had one person where this was actually at issue. Usually no one involved is in the military. Being a veteran is not enough. You have to currently be serving. So it's just one of those forms that is part of the packet. It's rarely actually leads to anything further beyond that.
So just to clarify, this is a form on the probate court's website that any court can require, and Suffolk does require, but Middlesex doesn't. So what Donna's saying is it varies by county whether or not you're going to be asked for this particular form in a guardianship case, as opposed to a divorce or something else.
Thank you. The public assistance affidavit is on page 15. And that is just letting the court know, is the child on any kind of public assistance? Is the guardian on any kind of public assistance? It doesn't really impact the case. The court just likes to know what the situation, the financial situation is. Yes?
Does that count for the conservatorship, like as a financial asset? So if you're getting Social Security payments?
Yes. No, I'm saying yes.
Yeah.
Sorry.
Does the guardian have to apply also to be a conservator because of these assets?
Great question. So, no. For Social Security benefits, the guardian can become the representative payee, and so can be basically appointed as the person who gets the benefits on behalf of the respondent. And that alone is not going to be enough to then seek a conservatorship. The conservatorship is in cases where there's an estate at issue. There's a property that has to be sold. We had someone who wanted to deal with a trust. I mean, where there's actually money involved, then you need a conservatorship. But for cash assistance benefits, things like that, you don't need a conservatorship for that.
The representative payee is a Social Security concept, so it's not, the probate court doesn't do it. If you put representative payee in Google, you'll get the page that'll tell you how to apply.
But your point is well taken, which is if the guardian has no legal authority to handle money, how are they collecting welfare for this child and spending the welfare? And that's just sort of a strange tension, because if you go back to slide 7, you'll see that the statute says that the guardian can collect up to $5,000 per year for the ward. But TAFDC is a lot more than $5,000 a year. So it's just sort of a weirdness about it, and we just reassure clients it's not going to be a problem. You're going to be able to get SSI, you're going to be able to collect welfare and food stamps and mass health without a conservatorship. You do not want people to be doing conservatorships unless there's a real reason to, because there's a filing fee and because there's a lot of requirements about reporting, and it's just, I mean, you know what, it's a lot. It's a lot to take on unnecessarily.
Yes.
But if someone had like a small savings account or check for that, you would need the conservatorship.
If it's a minor child, it's probably going to be a Uniform Trust to Minors Act, right? Account. So there's going to be someone else on it. It's never going to be just in the child's name. So if that person died, then hopefully grandma as guardian can go to the bank and persuade them to change the co-owner to the guardian. Something like that.
If it's an adult. And then,
again, you would try to do the same thing. I mean, it depends. There's no
Depends
magic.
how much.
Yeah, there's no magic amount of money. If you said $10,000, I'd say absolutely conservatorship. If you said $100, I'd say it's definitely not worth it because the filing fee alone is $165 plus then the bond, so it's a lot more. But it's sort of $3,000 would be a time that you call from Ropes and Gray and say, is there any way we can work this out?
So the guardianship intake sheet is on page 17 of your packet. And this is, the intake sheet in the packet is the one that's used by Suffolk County. Again, this intake sheet is something that varies by county. So this is just the sample one from Suffolk. It's going to be yellow. It's just the biographical information about, again, in more detail about guardian, and parents, and who's living in the house. This is what the Family Services Office uses to run the criminal background check. So, in terms of where it says people living in your home, they run a criminal background check on everyone living in the home, as well as the potential guardian. On page 21, this is the affidavit of indigency, or the fee waiver. This is not usually included as part of the packet. You usually have to either request it separately or, find it online. If you're at the court clinic, we have a giant cart with all of these forms there, and we usually pull it out and add it to the packet. So I just don't want you to be confused when you get a packet and this isn't in there. It's not routinely handed out by Suffolk, but it's certainly very accessible. This is to allow a potential guardian to waive the costs associated with the guardianship. So there's no filing fee. Recently, Suffolk has, is it just Suffolk?
Yes.
Suffolk only has started charging litigants $15 to obtain the citation so that people can do service. And people have started paying this $15 fee at the time of filing so that their case is not delayed. So the fee waiver will cover the citation fee, and it will also cover service, including service by publication. Service by publication is very expensive, so it's very useful. But it's only available for clients who receive mass health or cash assistance of some kind, or whose income is less than 125% of the federal poverty guidelines. And all of that information is actually under Section 1 on the fee waiver itself. So you're not expected to know that offhand. You can just look at the form to figure out if your client's eligible.
And we have a chart on the cart, and there's more extensive materials that include the chart as well.
Right. So you will be able to know whether or not your client qualifies for this or not. Right. That's the short answer. And this basically is the forms asking the state to cover those costs. So it's not that they're not being paid at all, it's that your client doesn't have to pay them. So page 11 of this packet, we're kind of jumping around, is the bond, which I think is...
Bill should talk about the bond.
By all means.
He loves the bond.
This is a truly metaphysical document because by definition, the respondent has no assets and no income, and yet the guardian is posting a bond. But the guardian is not actually putting up anything because you always check I have to look at the without sureties box, But you have to do it, and you have to do it twice, because you have to do it at the temporary stage, and you have to do it at the permanent stage. And just to descend into minutiae for a minute, the bond has two sides. And if you print it off the court side, you probably will just get one side, and that's not good because the judge signs the second side. So you just have to be sure that your bond has two sides, and you do it twice. And I cannot explain to myself why we do it, so I could never explain to the clients why they have to do it. But they generally go ahead and do it if I tell them they have to do it.
I always tell the clients that it's serving the purpose of, it's making them into a fiduciary. So it's important that they recognize that becoming guardian does carry with it that they are in fact a fiduciary, which, as you might remember from law school, means that any money that they receive for the respondent needs to be spent on the respondent. As Bill points out, that's usually not an issue. There is no money to speak of, but it is good to just remind them that there is a obligation that comes with being a guardian.
If any of you can think of a layman's word for fiduciary,
yeah, right.
I'm all ears because I've not been able to come up with one. Let me know.
Okay.
Email me.
So page 19 of the packet is the motion for temporary guardianship that we mentioned earlier. This is the most free writing that you will have to do during the petition paperwork. This is about as much as it gets. This is explaining to the court why is there an emergency that merits a temporary guardianship instead of just waiting for the permanent guardianship to run its course. It is, as I mentioned, routinely filed for minors anytime that there's not a authorized legal caretaker for the minor. The court deems that an emergency, and VLP can help you draft that language the first time you're in court. There's some buzzwords that we often use to signify what's going on. So it's a place for you to kind of explain to the court what's happening, and you do have guidance in doing that if you want it.
On the motion for temporary guardianship, the scheduling at the court has gotten horrific. Before it was terrible, now it's horrific. And they're really like scheduling out 2-3 months. So some of the times, we're, depending on what you hear as the reason for needing it, we're sometimes routinely also filing a motion for a speedy hearing, which is available on the cart. And it's one more page, but it's not much more complicated. Just basically saying, I need to put this child in school, which shouldn't require guardianship, but that's a whole different
That's
issue.
the next slide.
I need to take them to the doctor, I need a passport, whatever the emergency is. And if you're hearing, it's not something that should wait a month or 2 months. You can prepare the client to say, well, if you don't like the hearing date you can always file this motion for a speedy hearing so that they have it in line and they don't have to wait in the long line twice.
That being said, clients will often come to court saying their case is an emergency and they need to see the judge immediately. That's likely not going to happen. That varies by county as to what counts as an emergency. Suffolk County takes a pretty strict interpretation that the child basically be gushing blood, I would say. I mean, a lot of people will come to court and say, I'm leaving the country on Tuesday, I need to get a passport, I can't get a passport without the guardianship. The court's not going to see that as an emergency. Poor planning, but not an emergency. So, one thing to consider in all of this, now that we've gone through all the paperwork, you see that it's quite a bit of paperwork that's involved. There is an alternative to getting the guardianship, which is called a caregiver authorization affidavit. It's this nifty 2 to 3 page form that the guardian has to sign and one parent has to sign in front of a notary, and then that's it, in the sense that you don't have to go before a judge. It's self-executing. You don't need the court's involvement. There's no notice requirement. You don't have to give the other parent notice. It's more informal in that sense, but it's valid for 2 years. And it allows a guardian to take the child to the doctor and to enroll the child in school. And those are 2 common reasons why people come to court seeking guardianships. And this caregiver authorization affidavit allows them to do what they need to do, without having to go through the court system. And as you've heard, there's a bit of a backlog. They're usually there to enroll the child in school because it's August and school has, it's about to start or it's already started. So in terms of getting the kids enrolled quickly, this is your best bet. It is really good for cases of domestic violence where you don't want to give the other parent any notice of what's going on. This gives the guardian a lot of authority, the caregiver a lot of authority without having to give a parent notice of an address or, where the child is or anything like that. It's also very good for step-parents who have no legal authority under the law that, a step-parent is not considered a full parent. So this would allow the step-parent to take the kids to the doctor, put them in school, that kind of thing, without having to go and get that full guardianship.
Okay, so I'm going to do the same with the petition for guardianship for adults. If you could turn to that packet. This is in some ways a shorter packet, so it goes more quickly. The required forms is this slide, so there's fewer than for a minor child, but it's important to make sure you've got all of them. And similarly with minors, the military affidavit, Suffolk's going to want, other counties won't want. So again, the client comes out with the packet, and we can help them. The big difference, I think, with the adults is that we start with where's your medical evidence and is it sufficient. So someone at the table, Donna, me, Charisse, whoever is there, would start with looking at the medical evidence and making sure it's valid, it's up to date, and then ask you to work on it. So you'll already know that it's valid. Sometimes if it's busy, and the person really is having trouble sort of understanding, I might hand you the clinical team report and say, could you please sit down and spend 10 to 20 minutes with this person explaining what this is and that they have to go get this signed by all the signatures, because they need more time. They need to be understood and to be heard. So that sometimes has to happen. Okay, so the hardest part, I think, about a guardianship of an adult is getting the medical evidence. That's really sort of the big hurdle at the beginning. For a medical certificate, it's valid for 30 days from the date of examination, and there's one in the materials on page 7. And it can be signed now by a physician, psychologist, psychiatric nurse, or a nurse practitioner, which is good. Poor people tend to see nurse practitioners rather than physicians, so that was a good addition. But it's only good for 30 days. So if you're seen on October 1, it's only good through October 31. A clinical team report, on the other hand, is good for 180 days, or 6 months. Page 15, thank you, Donna, is a sample of a clinical team report. A clinical team report is what you need to use if the person is intellectually disabled. That's the difference. A medical certificate is the whole world except the intellectually disabled. Intellectual disability is the clinical team report. The clinical team report has to be signed by 3 people. So it's not one of 3, but 3 people. A licensed physician, a licensed psychologist, and a licensed social worker. It goes on to say these people have to be experienced in the evaluation of intellectually disabled persons. We have on the cart a list of psychologists. I reached out to the Massachusetts Psychological Association and asked would there be any psychologists who would do some work for us pro bono. It turns out psychologists don't do things pro bono. They're not like lawyers. But we got some cheap people, like $300 to $500, which is pretty good cost, which the client would have to come up with. But these are people who will come up with the money if they have to. We also have collaborations with several schools in the Boston area and Children's Hospital and Boston Medical Center to help us get these clinical team reports for people. So sometimes they come to court thinking they're going to leave with a guardianship, and all they leave with is this form to start working on. So they're pretty disappointed, but you might be taking some time to explain it. If you take a case or you have one at court, the medical certificate and clinical team report are very interesting to read. It's very worth your time to sort of look up words you don't know, pick up a little bit of medicine as you go along so you understand the nature of it. On the medical certificate, it's really important to look at whether there are any antipsychotic drugs, because if there are, that's going to trigger the Rogers Authority Donna referenced. and we would help you with all of that. There's another document called a medical certificate affidavit that's not in the materials that I would tell you it's not helpful. So in the same way that that nursing home form came into existence, this form is equally unhelpful, in that the person has to be represented by counsel to be able to use it for a final disposition of lack of capacity. So it's really not helpful. For a while, the court had them in the packet, which was really confusing to litigants, and we lobbied and they took it out.
Just to note, the clerk's office at the court does not always, depending on who you get, know the difference between the medical certificate and the clinical team report. So luckily,
and the clerk in David's case didn't know the difference.
Yeah, I mean, it's not unusual. So the good news is that the report itself tells you, the clinical team report and the instructions for completion has on there that this is used for persons with an intellectual disability. So that's how you can remember. Sometimes the clerk's office will pass out packets of the guardianship of adult paperwork that include the wrong form, and I cannot tell you how frustrated clients are when they come to us. We turn them away because they don't have the medical forms completed. We tell them what they need. They go get the form from the clerk's office. They go get the doctor to fill out what needs to be filled out. They do all that. They come back, and it turns out the clerk's office handed them the wrong form, and it's not going to do them any good, and they've got to start the process over. You can imagine how frustrating that is. So, as Veronica was mentioning, when people come to the table and are looking for help, and she may, or whoever's at the table, may ask you to sit down and explain what's going on, make sure you tell them which form they need and even get them the form that they need, because that will do them the most good. And there is a big difference between the med cert and the clinical team report, and the court's not going to accept the other one, depending if it's an intellectually disabled person who is the respondent, they're not going to accept the med cert and vice versa. Yes?
When you say intellectually disabled, if it's something like Alzheimer's or someone had a stroke, that's
med cert. That's med cert. So if someone is mentally retarded, that means intellectually disabled, then you need the clinical team report. And basically the way I think of it is that intellectual disability is a little bit more serious. It's, something that someone's had from birth. It's something that's affected them longer. And so therefore the report is more detailed. They need 3 signatures instead of 1. It's valid for a longer amount of time. It's kind of my way of thinking about it. I don't know if it makes sense to anyone else, but it helps me.
I think that with pro se litigants, mentally retarded means a lot more to them than intellectually disabled. So although it's politically correct to say intellectually disabled, they understand when you say mentally retarded. So feel free to use that. Say, I'm sorry if this offends you, but they used to be called mentally retarded, and then they'll understand. And they'll say, oh, yeah, she has Downs. It's like, oh, well, okay.
What's really nice, though, is that when you guys take on these cases through VLP, the medical certificate or the clinical team report will already be dealt with, because VLP won't help people at the table fill out the full petition paperwork until they've got this medical paperwork completed, because as you can see, it can sometimes take people months to get the 3 appointments that they need, that they can get everything signed off on and valid and updated. So to the extent that you're finding this to be overwhelming, the medical certificate and clinical team report portion of the case is usually dealt with already by the time you take on a case.
Just so you know, the medical certificates and clinical team reports are supposed to be impounded by the court, so they go into a different file, and they shouldn't be in the general file because it's sensitive information. But if you happen to pull out a file and it's there and it shouldn't be, don't be shocked. It's supposed to be segregated. So I want to walk you through the petition and sort of explain to you. This slide just as a sense. There's a form which I didn't bring, which is on our cart, but I don't know that it's on the probate court's website, that anyone who wants to agree to the guardianship can sign. So it makes it easier. You can just avoid service if they go home and get all the assents. So maybe someone comes and they don't have the medical evidence they need, so they're going home anyway. You say, okay, Christmas is coming up, New Year's is coming up. Get everyone to sign one of these when they come over. And then you've got all the assents lined up at the beginning. You can see I'm a real fun time at a party. I'm always thinking about these assents.
And sign a healthcare proxy.
And sign a healthcare proxy while you're there. So let's look at the petition. It should all make sense to you because we've just gone through the law. Paragraph 1 is asking about the demographics of the respondent, the data, address, phone number, what language the person speaks, where are they going to live after the guardianship. And then it says respondent is or is not alleged intellectually disabled. What difference does that make? Why does the court ask that? Yes?
Because that's for the clinical team.
Excellent. You get an A. Donna will buy you lunch.
I should have brought stickers.
Donna will buy you
They're in my
lunch.
office, sorry.
Paragraph 2 is the information about the petitioner. You don't have to have a co-petitioner, but if you do have one and you were on the computer, you would click on the X and a new window would open up that you can fill it in. If you're at the court, you're going to squeeze it in. They usually live together. Above Gretchen Guardian, you'd write Gary Guardian. State your interest in the appointment is just the reason for the guardianship. It's usually is the mother, takes care of her on a daily basis, something pretty straightforward. And then paragraph 3 is the petitioner's requesting to be appointed. It's usually the petitioner requesting self-appointment rather than appointment of somebody else. Oh my goodness. What happened?
Does everyone's page look really funky?
Yeah?
Yeah.
Okay, sorry about that. Our copier was not working either. So paragraph 4 asks why the person has a priority, and there's a box on the right that talks about being the parent, which is usually the case rather than the spouse. Paragraph 5 is about limited or general guardianship. As I said, in our cases, we're looking at general guardianship invariably. We don't see limited. If you get an interesting case, maybe your second case, we did have one where the respondent got counsel because there was antipsychotic drugs and wanted to limit it so that the adult respondent could pick which video games to play or what clothes to wear, things like that. It is interesting. I mean, a lawyer is supposed to be working to make it limited, so they were making every effort to see what capacity the person had. Paragraph 6 is whether you're filing a clinical team report or a medical certificate, and you're always going to say it's filed with the petition unless it's already been filed. And then paragraph 7 and 8, which you can't really read, says what's the reason for the guardianship and what's the nature and extent of the alleged incapacity. And we just write C, the attached, whatever, medical certificate or clinical team report, so you're not typing it over and writing it over and over again. Okay. On page 3 is this handy-dandy chart where you put in all of the relatives that are appropriate. So it says, paragraph 9, list spouse and children, period. If none, list parents and brothers and sisters. If none, list heirs apparent. So if somebody has a child and 3 brothers, who do you list? The child. Do you list the 3 brothers? No. Very good. If someone has no children and has no spouse, and mom is dead, dad is dead, and has 3 siblings, who do you list? The 3 siblings. It's pretty straightforward. It's simple reading. Our clients can't do this. They can't do the if none and period and stop, and it gets complicated. This includes half siblings, so I then say, do you have any other children? Does the child's father have any other children? And sometimes they know and sometimes they don't know. You can only list what you know. And then for each person, you're going to give their name and address and phone number, but also indicate what they are. What's the relationship? Is this the representative payee? Is this the healthcare proxy? And they want to sort of see it all here in one place. We have multiple pages of page 3. We have other copies, so you can add if there's, if you start at the beginning and they have 8 siblings, you're going to need some more sheets, so you want to get that up front. Did you have a question? No? Okay.
I do.
Yeah.
Could you please explain, so what does it matter? Why do they care if someone is minor or incompetent?
That's a very good question, Donna. If the person doesn't lack capacity, the court could appoint a guardian ad litem to represent that incapacitated person. Same thing with a minor child. This is kind of strange because I still do service by mail on the minor or incompetent person because that's what I've been ordered to do. But the other side could say, well, the in-mail service on this incompetent or minor child is insufficient. And then the court would have to take some other steps. Is that what you wanted me to say? Okay, I wanted to know if there's something else. Okay. Paragraph 11 is the person entitled to veterans benefits. What difference does that make? Does anyone remember from the slide? You'd have to give notice to the Veterans Affairs, the Department of Veteran Affairs. I don't see that very often, but you might. Does the respondent have any assets or income? Paragraph 12 is assets, paragraph 13 is income, and they want you to list the asset without indicating the institution. So it says something like savings account or checking account or bank account, but you're not supposed to put the name of the bank. It's very strange.
Some clients put the account number on there.
Yes.
And
Even
that's
though
why
it
this
says-
is on, even though it says don't do it. So you'll get, like the long list of numbers, and then it's like,
No.
all the court employees can see that. Not the best situation.
So something that we have at the cart, which is kind of retro, but is very useful, is lots of whiteout. It's strange. We really use it. So, you're going to make mistakes. They're going to give information. They're going to change the information, and we use whiteout liberally. Donna has her own private stash because she feels so strongly about which one she uses.
The worst, though, is that you've done the entire petition. You do it. It takes you a long time. The client, speaks another language. There's a language barrier, whatever. You finally get through it. And then the client kind of peeks over and she goes, you spelled the child's name wrong. And you have to go through the entire thing and correct it, which you are all looking at me like I'm crazy. But let me tell you, if you spent 2 hours writing the child's name over and over, you could kill the client.
It's not rude to say, do you have anything with the child's name on it? I want to make sure I spell it correctly. It's not rude to ask the client, especially with not simple English names. If it's at all complicated, get it right the first time. Do you have the child's mass health card with you? And then you get the name correctly. Because what you'll find, I don't know how much experience any of you has working with poor people, but they're not going to say you're wrong. They're not going to sass you back. They're not going to ask you questions. They're just going to sit and do what you tell them to do. So you have to give them permission to ask you questions. You have to give them permission to tell you you've just done something wrong. You have to say, does this look right? Did I spell it correctly? Because otherwise they will sit there quietly. They won't ask you your name. They will not ask you your name. They're going to give you their whole life story and walk off with whatever you give them. So you really need to sort of empower them to say, you didn't spell my name right, and then do it correctly.
Do any of you speak a different language?
I was going to ask that before our friend left. Excellent. What do you speak?
Spanish.
Excellent.
I speak French.
Spanish.
Oh, great. Do you think you could speak with Haitian Creole clients, maybe?
Yes and no. I mean, I can sort of, I've spoken with taxi cab drivers
Right.
before, and to the extent anything is written in Haitian Creole,
Yeah.
it's a lot easier for me to understand it.
Right.
Because then the writing is often more similar.
But it's a tremendous resource. We always have a Spanish speaker at Suffolk. Donna speaks Spanish, I speak Spanish, Bill speaks Spanish. So it's just that important. We just see that many Spanish speakers there. And so if you don't speak Spanish, you'll just get an interpreter or you'll get a different case.
But we don't have a Haitian Creole speaker
No.
in court, so we
That
know
would
that
be
you
great.
don't speak Haitian
Right.
Creole. No one's expecting that, but to the extent that you are able to come and even kind of direct the person,
That'd be
to the
really
clerk's
helpful.
office, that would be good.
The paragraph 14 is where you ask for any other special authority, like if you need to put the person in a nursing home, if there's antipsychotic drugs, if you need to administer electroconvulsive therapy, shock treatment, whatever, revoke a healthcare proxy, get a passport, leave the country for a vacation, whatever you can think of. If there's anything unusual going on, you'd want to ask for it. And then the prayer for relief, you're asking for general guardianship or limited for the petitioner or petitioners. And on the back of the petition is the part where you're waiving sureties, which Bill talked about. And then it's going to be signed under the pains and penalties of perjury and dated. And here on this page 6, you can see that there are places where that people could assent. Family members can assent on this form or on the separate assent form. And Donna didn't mention it, so I will here. Your name is not going to be on anything. If you're helping someone at the clinic, your name will not be on anything. They won't ask your name. They won't know your name. You're just doing it anonymously. And that's why we stamp the front with that stamp that says print prepared with the assistance of counsel. It's permissible ghostwriting under the rules of ethics. Massachusetts now allows ghostwriting under limited representation, and we'll talk about how you do that. So you don't put your name on anything. The client's going to sign everything for him or herself. And something else I want to mention is if at any point during the process at the court clinic you're hearing information that makes you uncomfortable for whatever reason, you don't want to continue, just let us know, and we'll, if you're feeling that way, we'll pull the plug. There's something going on. We had someone just Tuesday, we were doing the criminal record information on the yellow sheet, and she was looking for guardianship of a minor child, and the question was, what's your father's name? And the volunteer wrote it down, and then she says, I don't want my father's name on it. He never acknowledged paternity. He's not on my birth certificate. He's had no involvement in my life. So the volunteer whited it out and called me over, like, you deal with this. And I explained why it was there. It was just a criminal record check. If you know who your father is, we really should list it. And if she had said, no, I'm not listing it, I would have stopped and said the lawyer can't do anything knowing it's not false. It's knowing it's false. So we're not asking you to do anything unethical. But then she said, okay, and gave it to us again, and the person wrote it in, and we were back on track. So anything like that, any red flags go up, just let us know, and we'll figure it out. So that's the petition, and I hope it isn't that daunting. Having sort of heard why everything is there, what the law is, I think it's pretty straightforward. And Bill, we're now at the hearing before the judge part of it.
So you've done all this great work, you've gone through the process, and now it's finally time you get to go see the judge. Bill, did you want to talk about this part? Please.
Well, I have a very short speech about it.
That's perfect.
I think it's a good idea to write down what you want to say, because in the probate court in Suffolk, there's lots of people. It's kind of chaotic. The judge doesn't have a lot of time. And what's really useful is if you tell the judge in a few sentences who you are, who the client is, and what you want. I mean, it's really just that simple. I'm A, I represent B, who wants to be the guardian of C, and we're asking for, and that's it. And the judge may have a question or two. Recently, my experience is not much. They're under such pressure. They usually say something like, good luck, or how are things going? Something's not adversarial. It's intended to make everybody feel comfortable.
Right.
That's really it. But if you haven't done it before, writing it out just will make it easier for you, and it's a good experience.
David, what was the hearing when you actually saw the judge?
I didn't actually get to stay for that part.
Oh boy,
because
it was so late. I'm sorry.
No,
So if you do have a hearing, it's important to tell the client to get there early, because you're in line behind everyone who got there before you, right? So it's like checking in. But everyone is scheduled for 9, so it's a huge cattle call. It's a disaster scheduling wise. But it's important to be there on time, and you can explain to the client that you want to get there early so you can get in and out a little bit quicker. Always let the client know he or she should make arrangements for childcare that day. Don't make plans to have a 1 o'clock haircut. It's too risky. So just plan to be there, and hopefully you'll get out in time to make whatever afternoon appointments that you have.
And usually, I just want to clarify, your case is unusual. You are able to go to court in the morning and be done by the afternoon. For the clinic, always. But for a case, when you're there for a hearing, you are usually able to be done by the afternoon. It's just occasionally that, the file is lost, that it takes a little bit more time.
You're usually going to have to go to the Family Service Office to get a criminal record check. You want to check in with the clerk and alert the clerk if you have any time constraints or that you have an interpreter. It's always good to mention VLP. And this is the one time, and this sounds strange, but it's the one time you can say to the clerk, this is my first case. I'm not sure I'm doing everything right. Can you look over, give me any advice now? Usually you don't admit you don't know what you're doing to people, but it will help you, because they'll then understand and make sure it's all right. The hearing is very short, but you do still get to get dressed up and go be a lawyer, so I think it's fun, and I think you'll enjoy it. At the court, just before I forget, the clerks are all lawyers. The one who sits, the judge's right-hand person, is a lawyer, but in the clerk's office, they're not all lawyers. So if you know you're right, you're right. Don't let this non-lawyer persuade you that you've made a mistake. Go out in the hallway, look up what you want, call me, call Donna, and then go back in. So like in David's case, where the clerk was saying, oh no, you need a medical certificate, this is outdated, they were going to say, okay, and leave. And that wasn't true at all. So don't be afraid to stick up for yourself. After the hearing, make sure you read anything the judge has given to you for typos, because it's a lot easier to fix a typo while you're there in the building than to go back in 2 weeks and fix it. Sometimes they'll say to you, oh, we'll mail it to you. You can leave. And you're like, great, I get to go. It's really better to say, if you don't mind, I'll wait. Because the amount of time it's going to take you to go back to court when you haven't gotten it in 2 weeks and look for the file that's lost and get it reissued, you will save time in the end. Do you agree?
Absolutely. Yeah.
Just wait. Be patient. Bring other work. Bring a book. Whatever. So how to volunteer. Do you want to talk about how they volunteer through
Sure.
ropes?
Oh, okay. So, well, generally speaking, there are 2 ways to volunteer through VLP. I'll talk about the ropes in a second. So there's this clinic that we've been mentioning throughout the presentation, and the clinic is in Suffolk Court 2 days a week, Tuesdays and Fridays. The Tuesday clinic is just guardianship, and the Friday clinic is both guardianship and family law.
Oh, sorry.
No, that's okay. So if you have an interest in family law, Friday might be a better choice for you. Tuesday is mostly focused on filling out the petition paperwork that we just went through, whereas Friday you'll do petition paperwork for guardianship cases, but you also might have the opportunity to actually go into a court before a judge and argue. It's not so much argue, but represent someone for their divorce hearing, the final hearing, or to work on a separation agreement, or to work on a child support worksheet, or things like that. So it's also family law. You might actually get into court. So if that's something that interests you, Friday might be a better choice. If you would rather just stay behind the scenes and have that experience with the client in more depth, Tuesday might be a better choice. VLP is also really good at accommodating what you prefer to do. So if you let them know, I've had a training on guardianship, I'm really interested in guardianship, I'd love to try that, then they're not going to give you the divorce that walks through the door. They're going to give you the guardianship case and let you do that. That's the clinic idea. There's also the idea of cases, and the cases are after the clinic happens, after VLP helps these clients in court, they then refer the cases to private attorneys throughout Boston, throughout Massachusetts, to assist in the full-time legal representation of the case beyond that first experience. So handling the service, going to the hearings, that would then get to be what you get to do. They're both great experiences. I think it depends on the type of commitment you're looking for. If there's a morning where you're like, I know I'm free, I have nothing going on, go to the court clinic. It's from 9 to 1, and then you're done. If you meet someone at clinic that you are really inspired by, or you really want to keep helping them, of course, you are more than welcome to say, can I please take this case on, if it turns out that VLP is going to end up representing them, and then you can take it back to the office, work through the conflicts check, work through the service, work through the hearings, and that's then your case for the next 3 months or however long it takes you. So there are a lot of different opportunities. In terms of what ROPES requires, ROPES is really good about supporting all of the VLP work. VLP is an approved partner, so you don't have to go to the pro bono policy committee to get special approval. Any case or clinic experience through VLP is approved already, so that is great. And you do obviously need to let the powers that be know that you're working on this case. Deb Russo or the corporate person, I'm sorry, I'm litigation, I don't know, Tracy maybe? In any event, are any of you guys corporate, or is everyone litigation? Do you know who I'm talking about? The staffing person?
Yasmin.
Yasmin, thank you. So you will need to let them know that you're taking on this case in your weekly reports, just so that they can keep up with that. But it's not an inordinate amount of work on the ropes end to make it happen. Please do sign up on Volunteer Hub. The website's listed on the slide if you're going to be going to the guardianship clinic, just so that VLP knows you're coming. And what ROPES would prefer is, if possible, if you could email Kathy Falkenstrom, who's Roz Nasdor's assistant, to let her know that you're going to the clinic. She likes to keep track of that, so please do that as well.
So if you're going to come to the clinic, technically speaking, you're supposed to do this limited rep training, which is a 2-hour audio. It doesn't say you have to pay attention, it just says you have to listen. And you fill it out and you mail it and you won't get any acknowledgement or receipt, it just goes into a black hole. So if you could do that before you come, that would be great. And we have the stamps at court to stamp and prepare with assistance of counsel. And the last thing we just wanted to cover is why volunteer. And I don't know of anyone who does it better, more eloquently than Bill. Having heard his description of the bond, you can now hear why you should do this.
Well, I think I've already said that I think it's important work because the people that you end up representing, everybody has a story. So, it's easy to lose sight of that in all the paper. But when you talk to clients, everybody has a story that got them to the point that they're at. And you make an enormous difference as a lawyer. And all you have to do is watch a little bit in the probate court, and you'll see people who are unrepresented really don't know, what they're doing or how to do it. And so you can make just an enormous difference to the outcome. So I hope everybody will try it. There are 2 cases on the list that Russell has sent us that are uncontested. They're incapacitated adult guardianships. They're very straightforward. And if anybody's interested, we can take these cases and we can do them collectively.
You can team up on them.
And
it can be 2 people.
We also have. We also have mentors, more senior associates, really still junior associates, who've agreed that they are happy to serve as mentors to any of you. So if you don't feel comfortable taking a case on your own, there are people who can take those cases on with you.
I think anybody especially anyone who's in the litigation group here, this is an opportunity to appear in a courtroom before a judge. And that's a very valuable experience, even though this is a brief kind of hearing. So, think about it, because I think it's something that if you do it, I'm pretty well convinced you'll enjoy the experience and hopefully want to do another one. We would love to be able to provide a lawyer for everybody who needs one on the guardianship side. And I personally don't think there's any reason why we can't do that.
Well, that would be great, because there are a lot of people that we turn away, and unfortunately I have to, people call and I'll say, I'm sorry, I just can't find you a lawyer on such short notice, or I'll try, and it just doesn't happen. And there are a lot of people at Ropes, the names are flooding my head, but Patrick Kernan's been incredible, Jill Ambrose has been incredible, Alyssa Kohlmeyer. There are a lot of people who come on a regular basis and really will step up and take a case. Gretchen Green has done a lot of cases, and every so often I get sort of the wrinkle case. So if you come to the clinic and you're comfortable with the easy ones, we might tap you to say, would you consider taking this one? Especially now while you're not that busy, while your caseloads are building and you're trying to find ways to educate, what's it called, professional development. In part of your professional development, come to court, do some petitions, watch the court, get a tour, and you're actually helping someone while you're doing the professional development. Anything you want to say?
I mean, I highly encourage everyone to do it. I can speak at length about it, but I want to make sure we save time for questions. So, does anyone have? Yes.
I have a few questions. I have
Please.
One question for Bill, and this is just kind of mechanics. What's the easiest way for us to get you the engagement letter to be signed?
Well, that's a good question, because we use a form. It's a short one, right? And I have a personal email, which I prefer to use because remote access to Ropes and Gray is a sometime thing. But I always get email that people send to me personally. And I'm glad to give you my personal email. It's wlpatton@mac.com. And if you just send me the draft, I'll be glad to take a look at it. In guardianship cases, very straightforward. What we're saying is we represent you in seeking the guardianship of X, and we'll represent you through the hearing on the permanent guardianship.
Can you repeat that address? Some people couldn't hear it.
It's wlpatton@mac.com.
MAC.
MAC.
And then do you sign it and mail it back to us?
Yeah, I come into the office actually fairly frequently, and I can sign it and send it back that way, or I can sign it in the office.
Then can I ask
Absolutely.
other questions still? If we have a case and there's no hearing date yet, how do we get the hearing date?
So when there's no hearing date, what that means is that you have to wait for the return date, the deadline by which objections have to be filed to come and go before you can ask for a hearing. So I think one has a January 3rd return date. So that means that on or after January 3rd, you go to court and say, I want a hearing date. And it'll be some subsequent Tuesday in that case. That's it. And you'll have control over, no, that date doesn't work for me, or this date does.
It's the best part.
It's pretty straightforward. And I think in one, if not both of those, we've done service of process already. So it really is meeting with the client, preparing for the hearing, and going to the hearing.
If anybody wants to take these cases, I mean, I'll be glad to go down to the court with you and show you how to ask for a hearing date.
This is an extraordinary offer.
Yeah, I don't know if you guys realize that was...
It's a colorful experience. I assume everybody, when they were younger, must have read Bleak House by Dickens. If you haven't, you should think about reading a copy. It's a good introduction to the Suffolk probate court.
If you have a chance to go to court with Bill, make sure you spend some time with the cashier, his favorite character.
Veronica wants to do a Saturday Night Live skit about the probate court.
That's what the next training's going to be.
Right.
It's really good. And if you can't tell, we enjoy this work. We like each other. You'll have fun when you're there. It's as much fun as you can have trying to help people on one of the worst days of their lives.
It does make everybody a better citizen. I know this sounds a little bit corny, but the fact is, when you represent people, you find out a lot about you'll look at public policy issues somewhat differently after this. Because the way things operate, I personally find most of the political debate about these issues completely removed from the reality that people face. I mean, mass health is Medicaid, right? If you want to see how that works, people will tell you what their experience is. Public housing is another whole Byzantine area that you will hear about in doing these cases, and there's occasion sometime to learn about it. So I'm really a big believer in these cases.
Do you have another question, David?
So then I was reading the manual online and it talked about filing all the forms in person. So do we normally go in and file the petition?
Yes, it's best to do everything in person. If once you're there, you were there, would you mail anything to that clerk's office? No. It's just a black hole. So it's really better to do everything in person, make a copy before you go, and make sure you've got what you need. So we don't advise mailing anything.
So ROPES does have paralegals who are designated to be helping with the Volunteer Lawyers Project. Molly Kavanaugh and Mark Callahan, and if there's ever a time where you need to file something in person, depending on what it is, you may need to go or they can go, so that you don't have to spend your time going to the court. So they are also good resources that they're available if you need some help as well. So feel free to reach out to any of us if you've got questions, and we can stay a little bit longer beyond, but we have reached the end of the time, so I don't want to keep anyone longer. But if you guys have questions, we're happy to stick around. And, of course, you know where to find me on the InfoNet. Feel free to reach out. And I hope to see all of you at clinic. And I hope that you guys will all take cases. So thank you for coming today.
I look forward to working with all of you, too.
Thank you.
Thank you.